So thank you again for joining us. We will begin. And Maury, can you start out by giving us a refresher on the state of Florida's non-compete statute?
Sure. Thanks, Rachel. And again, happy birthday, Melody. Thank you all for attending. The Florida non-compete statute, and those of you who I've had the privilege of working with have heard me say this before. It, it is a statute driven concept in Florida. It is 542.335 in the Florida statutes, and it reads as a checklist. Literally, and I'll go through the highlights of the statute with you, but in the very beginning of the statute, the two things are made clear. The statute provides that a non-compete in Florida has to be in writing. It has to be signed by the person against whom it will be enforced. Then the statute provides, and I'll just read it to you to show that it is just a statute that is a checklist. It says or provides the person seeking enforcement of a restrictive covenant shall plead and prove the existence of one or more legitimate business interests justifying the restrictive covenant. That's the guts of this statute. A person seeking to enforce this non-compete has to plead and prove a legitimate business interest that supports the restrictive covenant. So what is a business interest worthy of that? The statute goes on to list or identify 5 or 6 of them. It could be a trade secret. It could be confidential, valuable business or professional information that is otherwise not a trade secret. It could be a substantial relationship with a prospective or existing customer. The prospective customer has to be a specifically identified prospective customer. It's just not future business. It could be customer or patient or client goodwill, as long as that goodwill is associated with an ongoing business or professional practice, trademark, service mark, trade dress. It could be a specific geographic location or a marketing plan or trading area. And then the last of the legitimate business interests identified in the statute is extraordinary or specialized training. Now, I'm sure during today's webinar, you'll hear Melody and I talk about the importance of specialized or extraordinary training. The statute goes on to provide that a restrictive covenant not supported by one of those legitimate business interests is unlawful, void, and unenforceable. So that's why these statutes, statutory enforcement of them, and the contracts themselves go out of their way to identify the particular business interests that you're going to rely upon. A person seeking the enforcement of a non-compete in Florida has to also prove that the contractually specified restraint is necessary to support the enforcement. And what does that mean? We'll talk about that during this hour. The person opposing the enforcement actually has the burden of proof in Florida of establishing that the contractually specified restraint is overly broad, is overly long, or is otherwise not reasonably necessary to protect the legitimate business interest. Interestingly and importantly, Florida's statute actually codifies and provides that a court shall modify a restraint that it determines is overly broad, so that it grants only the relief that is necessary. And that's why when Rachel, Melody, and I draft agreements for you, we always put in a savings clause that says, essentially, if the court determines that the provision is too broad or too long, reduce it to what the court determines is reasonable, because the court has the statutory obligation to do that. The statute also defines the length of a restrictive covenant that will be enforced. It does it negatively. And the statute provides that a restraint of trade, when we're talking about a former employee, of 6 months or less is deemed reasonable, and a restraint of more than 2 years is deemed unreasonable. So ordinarily, my sense about this is you asked for a 2-year non-compete because the court will likely enforce it in Florida, but it will depend. If you ask for longer than 2 years, you're probably going to have the court reduce it because of this statutory provision that says if it's longer than 2 years, it's presumed unreasonable. It doesn't mean that it necessarily is unreasonable under the circumstances, but it's presumed to be unreasonable. And then there are different lengths of time depending on the particular circumstances. If you're selling a business, the presumption can be that it's as long as 7 years. But again, these presumptions are just presumptions and they will require proof. Importantly, later in the statute, there's a provision that reads, and I think it's important to read it. The court shall not refuse enforcement of a restrictive covenant on the ground that the person seeking enforcement, will suffer economic hardship. That's not a defense necessarily to the enforcement of the non-compete. The statute goes on to provide that in determining the enforceability of a restrictive covenant, as I said, the court shall not consider individualized economic hardship. The court may consider as a defense the fact that the person seeking enforcement is no longer in business. So if you go out of business or you drop a product line, you're not going to be able to enforce the non-compete. And then the court is simply directed by the statute to consider other legal and equitable defenses, which means the person seeking to avoid the non-compete can argue whatever they want, and the court should listen to it and then make a decision. Interestingly, the statute also provides, because I think it's an employer-friendly statute, there's a directive that says a court shall not employ any rule of contract construction that requires the court to construe a restrictive covenant narrowly against the restraint or against the drafter. Rather, the court's instructed to enforce a restrictive covenant by any appropriate and effective remedy, including, temporary or permanent. And finally, there's a statutory provision in the statute that directs the court, in the absence of a contractual provision, to award attorney's fees to the prevailing party. So if you lose, you're going to pay the other side's attorney's fees, regardless of what the statute says. And if you win, you may or may not recover your attorney's fees because the court will grant an award of fees, which is different, and we'll talk about it later. It's different to receive an award than it is to actually recover attorney's fees. So that is the framework of the statute. It is employer-friendly. Doesn't mean these are easy lawsuits to prevail upon. These are expensive lawsuits. They are difficult lawsuits, but the framework is there if your contract is prepared to follow and track the statute to enable you to subsequently enforce it. But Melody, you've been taking a look at the court's reactions to these lawsuits. What are you finding?
Yeah, so I know we're all here to talk about the changing landscape. And I think something that's good for us in the state of Florida is that courts still do enforce non-compete agreements. There have been a lot of national headlines about other states and jurisdictions who are moving away from the enforcement of restrictive covenants and particularly non-compete agreements. And I'm going to talk in a little bit about the Biden administration's approach and some new things that are coming down the pipeline or anticipated to be coming out based on an executive order that was issued in July of this year. But first, what I thought would be helpful to do, now that Maury's given you the framework and shared with you what should be included within the context of your non-compete, is to look at a recent decision and see how the court applied the statute and ultimately created the law. So for purposes, in case you want the site so you can look it up later, there was a June 11th decision of this year, which occurred in the 2nd District Court of Appeals. That is just over in the Tampa area. The case was Surgery Center Holdings versus a number of physicians, but I'll give you the site, 318 Southern 3rd, 1274. And again, that was June 11th of 2021. And the background essentially on the case is that there were multiple physicians who left their employment with an ambulatory surgical center, and they went to work for a competitor. And the former employer, of course, files a complaint for breach of their contract and also files a motion for temporary injunction. And the circuit court, after a 2-day evidentiary hearing, which is essentially what we like to call a mini trial, the Hillsborough County judge denied the motion. And of course, the employer appealed. And at the district court level, what the court said is, look, these physicians had valid and enforceable non-competes. They were clear and unambiguous terms. The employer was entitled to a rebuttable presumption that it was irreparably injured by the physician's violation of the terms of their agreements, and that the employer had established that patient goodwill within the geographic scope, which in this case that I'm describing to you was 25 miles. That, in addition to substantial relationships with their existing patients, was reasonable and was a legitimate business interest that was reasonably related to those restrictive covenants. So the court sent it back down and said, look, trial court, you need to go back and enforce the non-compete. And in this case, there was also a non-solicitation provision that was not enforced by the trial court. And the appellate court said, no. The key takeaway to this case is, with all of the changing landscape here in the state of Florida, the appellate court has said, just in the last 2 months, non-competes are valid, provided that you follow the statute and you have a legitimate business interest and your scope is reasonable. I know that was one of the questions we received prior to the webinar is, look, if my geographic scope is reasonable, does that help me in enforcement? It most certainly does. And so in this case, 25 miles was deemed reasonable. It can vary based on not only your particular business, but also what the employee is doing for you, what their scope is, how far they're traveling, kind of what their territory is during their employment can help you to establish what it should be going forward that will be enforceable in the court. So I think for all of us on the webinar, the key takeaway and the highlight is, yeah, they're still enforceable. There's a lot out there about, courts not liking to enforce non-competes, and that is true to a certain extent. There are some judges that don't like non-competes, but there are plenty of judges that realize it's a contract that is enforceable just like any other contract that's enforceable. So the key item for you is to make sure that your employment agreements follow and track the statute, so that when it's time to enforce it, while in Florida we do have the blue pencil power that Maury talked about, where the court can go in and say, okay, you put 3 years. We don't agree that 3 years is reasonable. We do agree that 2 years would be reasonable. So we're going to change your agreement. We're going to enforce it, but only call it enforceable for the 2 years. So I think it's a positive case for us. There was another question about healthcare non-competes and whether there was a trend away from enforcing those. I think this case, there are 4, to my knowledge, very recent non-compete decisions that we've been following. And this one, I think, is the broadest scope in terms of applicability across the board, really having the court do more of a deep dive into all of the facets of the statute and reiterating what we have known in terms of how to set up the agreements so that they are enforceable on the back end when you get into litigation. So just a good example of what you need to do and how the court is affirming, yes, these are valid, these are enforceable, and they're very, real things that you need for your business. I'm happy to answer any questions on that. If you have them, please put them in the Q&A. But just to touch on the other aspect, something else that we've been watching very closely is the Biden administration. And what is the Biden administration's position on non-competes? And on July the 9th, there was an executive order that came out, which was called Promoting Competition in the American Economy. And it touched on a lot more than non-competes, but non-competes were specifically addressed within that 20-page executive order. And it really boils down to mobility for workers. So what the administration is asking the Federal Trade Commission to do is to come up with some additional regulations that will permit workers to be able to leave their employment in search of better employment. And there are a couple of sectors that were specifically highlighted by the Biden administration in the order. Those are the construction industry and also retail. We don't know yet, because the FTC has not published any guidance, whether it will only relate to those specific industries. There was some signal that it would be much broader, and we're trying to limit the ability of courts to enforce non-competes throughout the country. As you may be aware, there are several states which are much less favorable than the state of Florida on enforcement already. But this is definitely a signal that there will be more coming. We're certainly following that, but non-competes are part of the changing landscape. And I think that there will be a desire to allow employees, at least at a lower or more entry level of the spectrum, to be more mobile and to have opportunities to seek better employment, better working conditions or wages. And so we're monitoring how that's going to affect us moving forward here in the state of Florida. But right now, the state of the law is that your agreements are enforceable and can be enforced, provided that you do a good job, like Maury did for you, walking through the statute. As long as your agreement is set up that way, then you should be able to enforce your agreement in our court.
Thanks, Melody. I have a question on the drafting piece. Why do most non-competes have both a non-competition clause? I don't say most, many. Many have the non-compete clause, which appear to be designed to keep the individual out of the industry or out of a particular business line for a reasonable period of time. And then there's also the non-solicitation provision, which says that they cannot solicit the employer's clients or customers for a restricted period of time for the purpose of providing them the same products or services. Why have both a non-compete and a non-solicitation provision when the non-compete should take care of it?
You're me, Mel. I'll take a shot at it. I think that in many ways it's those of you who know me, it's a belt and suspender. But the reality is that to the extent, as Melody mentioned, that there are judges who don't like to enforce non-competes, it may be more acceptable that they will enforce a non-solicitation. So it gives what I call employer one, it gives them the opportunity to have two bites of the apple, not just one, and a fallback position should they end up in litigation and you run into a court that is just not going to enforce it. The other interesting question is whether or not the non-solicitation would or wouldn't be limited by the same time periods that the statute gives guidance on the non-compete. I typically encourage clients to draft them so that the time periods are the same and designed to mimic the Florida statute. But I've had discussions with clients that are looking perhaps to have a longer period of non-solicitation. I've not seen a case that addresses that particular issue, but intellectually, I understand the issue.
And I'm litigating a case now, Maury, where there are both covenants, but only one was allegedly breached. And so you can have an agreement where somebody's not competing again with their former employer or employer one, as Maury's calling them, but they are soliciting, right? So they're maybe moved to a new industry, but now they're soliciting your employees, or now they're soliciting your customers for a different business. So I think you can enforce different parts of the agreement without enforcing the whole thing if other parts are not in breach or in violation. And I think that can be a little bit confusing for courts. So I think you have to, do a good job in your pleas of laying that out. But certainly they are different covenants, and so I think they're intended to provide as much protection as possible for the employer, so that you're covered all around, regardless of what the employee does when they move on to their next employer.
Right.
Thanks. And then taking it to a different scenario, if one of the attendees on the webinar, their company is acquiring through an asset purchase, they're buying another company, and the owner of company two, the target, is going to come over to company number one. What are the time frames? What are some of the considerations on non-competes in connection with the sale of a business?
So the statute grants the ability to have a much longer period of time and to be burdened by a non-compete when it's in conjunction with the sale of a business. And I think the statute sets up a period that says a non-compete of less than 3 years is presumed reasonable, and one more than 7 years is unreasonable. So it's dramatically longer that you can request and maybe negotiate a period of non-competition when you're obtaining it in connection with the sale of a business.
Okay, so in that case, I think there would be one restrictive covenant then in the purchase and sale documents. And then if the owner of that company is coming over to also work for a period of time, then would it be the same 6 months or less? I don't want to say that. Is it under 6 months or 6 months and less? I always have to look that up.
Right, it's 6 months or less.
6 months or less is presumed reasonable.
Yes.
More than 6 months, up to 2 years is neither presumed
unclear.
reasonable or unreasonable,
Right.
and then more than 2. Okay. So for the employment agreement for that owner that's now sold their company and coming over to the new company, they're going to have an employment agreement with the standard provisions that run from the time they terminate their employment, but that could be a different time frame from the covenants that are in the purchase and sale agreement. So these are all the little things that we have to look out for and counsel our clients on.
Right, and I think that it's a, responsibility of the drafter to make sure those documents line up and answer the question that the court's going to ask, which is reasonable to predict. Well, which is the time period? Is it the one that's in the employment agreement, or is it in the one that's in the sale agreement? And you might want to tie those documents together in some form.
And I think, Rachel, another aspect that I know we've all dealt with recently is, what if company 2 is in a different state? Do we want to, because our laws are favorable here in Florida, if state 2 is not as favorable, do we build in the choice of law clause the provision that says Florida law should apply in enforcing this non-compete? And then, does state 2 enforce or not enforce? And I think we've seen that honestly depends on the state and whether they have public policy that says, if a state disagrees with us on, how we perceive the enforceability of non-competes, then, we don't care what the Florida courts say. We're not going to enforce beyond what we think is presumed reasonable for our state. So I think sometimes choice of law can be very effective in those circumstances where you have, one company in one state and another company or employee in another state, but it's not a fail-safe method to just include Florida, because you do have the instances where a court will refuse to apply our choice of law, even though that's the contracted provision.
Right. I think it's important to not only negotiate in a choice of law provision, but I try to the extent I could negotiate in an exclusive venue provision, so that you're hoping to get that lawsuit in Florida and have a Florida judge react to the lawsuit. Because I think that no matter, as Melody says, the strength of the choice of law provision is really dependent on the judge in a state other than Florida. And who knows what they'll do.
Okay. So one more question on this, and then we'll go to some that are coming in now through the Q&A. Since our Florida statute has a prevailing party attorney's fee provision on restrictive covenant litigation, and many times there's a separate contractual attorney's fee clause built into the agreement, with all of what is perceived to be uncertainty, perhaps, how does a client know what to do in terms of enforcing a non-compete when we don't know if the court in another jurisdiction will enforce Florida law, or we're not sure how it will be perceived by the judge here in Florida on the scope of time? What can you comment on that, please?
Melody and I have worked on several drafting conundrums over the past year for clients with operations in several states or many states. And we typically will take a look at the law in the state where the employment relationship will be. And we might have to involve a lawyer licensed in that state to take a look at the agreement. But it is true that, if you've got an employee in a foreign state, that state's going to have a reaction to your agreement, especially if the employee, quote unquote, beats you to the courtroom and files first in a declaratory judgment action, which I've seen happen several times.
Yeah, no, I agree with that, Mark, but I think, Rachel, going back to the prevailing party fee, I still think it's advantageous for employers to include it. There's always a risk with a prevailing party fee that the employer doesn't prevail on all aspects of the case, but the case law is such that if the employer prevails on the substantial portion of what the case involves, you're likely to get your fees. You may not get all of your fees. You may get a portion of your fees. And, you know, frankly, we do the analysis, the lodestar analysis to say, look, court, you know, the number of hours was reasonable. The time that we spent on this portion of the case was X. And, you know, this is what we want, you know, Y, the result, the fee award. So while it might not be everything, I do think it is better for the employer to have it than not have it, not only on the statutory side, but we always put it in on the contract side too, because I think it goes back to the belts and suspenders, right? It's better to have it in two places than one place or no places. And so I think that it also causes an employee who is considering violating their non-compete to pause when either they go back and look at their agreement or they get the demand letter from us that says, oh, by the way, reminder, you have a non-compete and it has a prevailing party fee provision in it. And so we're going to enforce it against you. And then you're going to be on the hook for our attorney's fees. So again, not a sure thing or not a guaranteed thing, but something I think that can be an important tool in your enforcement tool belt.
Thanks, Melody. Maura, you had mentioned a declaratory action. Can you explain that a little bit?
Sure. What I have seen in several instances is, including in the rare instance where we have represented an executive seeking to avoid a non-compete, if they are going or relocating to a state where enforcement and non-competes is not likely to happen, we've encouraged them to file first and file what's called a declaratory judgment action to say that in this particular state, wherever they are, that non-competes are disfavored, that they violate the public policy of the law of that particular state, and seek a declaration that the agreement is unenforceable under the law of X state. And we've seen that happen in Florida as well, where people have relocated to Florida and then sought to get out from under a non-compete that would not be enforceable under Florida law. So it's simply an effort to file a lawsuit, not for money damages, but essentially an injunction from the enforceability of the non-compete.
Thank you. We have a couple of questions coming in. The first is, with more employees working remotely, do we need to have into consideration, are we looking at Florida law? Do we want to build in a restrictive covenant agreement that's governed by Florida law, or do we want it to be governed by the state where the employee is physically located? And I think here that's where there is going to be a personal jurisdiction issue, meaning we are likely not going to be able to bring that person into court in Florida. We will have to go to where they are located and sue them somewhere else to enforce the non-compete. So how do we deal with choice of law in the agreements there?
Yeah, and I think it depends. You know, we do a lot of work all over the country looking at what different state laws are, and there's quite a wide variety. There's a number of states that are like Florida, frankly, that take a pretty similar view in terms of geographic scope, in terms of reasonableness for the length of the non-compete, and judges that have no problem enforcing non-compete agreements. And then you have some other states that it's virtually impossible to enforce a non-compete unless you prove, you know, very specific things. They don't permit the blue penciling that we talked about in Florida, where if you have one little term that they think is unenforceable, they just throw it out. You know, it's just not going to be enforced by the court. So I think we have to do a fact-specific analysis on, okay, where is the employee working remotely? And we know what that state law is so that we can counsel our client, look, putting in a Florida choice of law for this particular employee is not going to work. An example of that would be the state of Virginia. The state of Virginia and the state of Florida are on opposite spectrums in terms of enforceability of non-compete agreements. So you would not likely be successful if you were trying to enforce against an employee in Virginia. But if you have an employee in another state where it is more favorable, you would, likely be fine, including in Florida, and you may even get away with a Florida jurisdiction provision or venue provision provided that there was some nexus to Florida, more than just your headquarters being located there. But it can get very fact intensive in terms of the analysis on a case by case basis when you're dealing with different states and across jurisdictional lines.
Right, and as a overarching proposition, if you're a multi-state employer and you have an employee, you're based in Florida, and you have an employee living and working in another state, ordinarily it is the state where the employee lives and works whose law you need to comply with. So it may mean that you need to shop your agreement and have it analyzed under the law of that state where the employee is working.
What about independent contractors? Under Florida law, can we obligate an independent contractor to a non-compete?
I think it's a fascinating question. And those of you who have worked with me know I have quite a bias in favor of the employer. But the reality, and you would think, I believe, therefore, that independent contractors could not be burdened by non-competes. But the Florida statute specifically identifies and confirms that the Florida courts will enforce a non-compete signed by an independent contractor, which I think is fascinating. But at least in Florida, independent contractors can be bound by non-competes. The rules would be the same statute applies. You'd have to follow, plead, and prove the same types of things. But if you do that, you should expect in Florida that your document will be enforced.
And I think it just goes back to the general principle in the state of Florida that you have the freedom to contract. Right. And you can contract away your rights. You can, something we often recommend is a jury trial waiver, right? You have a right to a jury for most types of cases in Florida if you are sued, but we can say, hey, look, in advance, you're going to agree that you're not going to have a jury and we're going to waive that. And so just like that provision, you can agree as an independent contractor or as an employee to a whole host of things, and the court says we're not going to go behind and presume that that's unreasonable unless it meets these very specific requirements that we talked about earlier. And if it falls within that scope, it's enforceable.
And I think that, we're sitting here and we're saying that these agreements are enforceable. They are. But it really is a bell curve, and you should think of it in that way. There are, and I'll just talk about the local judiciary. There are judges in Florida who absolutely will enforce a non-compete agreement. And, I've been in front of them, and ordinarily the first thing a defendant will say is, I didn't violate the agreement, or what I'm doing is not prohibited. And I've literally had a judge stop the hearing and say, great, then you'll have no trouble honoring my injunction since you're not violating it anyway. Like, we're done, we're going home. I've had other judges that will simply say, I'm not enforcing the non-compete. Much like the case that Melody referred to, because they think they violate the fundamental competition concept that our economic system was ultimately founded on. And they're like, I'm just not going to enforce it. And then it will go up to the appellate court and we'll get a much more academic reaction to it. And then most judges will listen to the evidence and make the best ruling they can make by applying the facts that are before them to the law. But it is a bell curve, and it is hard to know what a particular trial judge will do in any given situation.
That's a good point, Maury, because I think also what some people on the webinar may not know, if you haven't been involved in litigation, we don't get to choose which trial judge we get, right? We all have ones that we would want, but it's not a system where we get to select which judge. So we file our paperwork and then we're assigned. In Orange County, we do have the complex business court. We know who that assigned judge is. So to the extent that your case, which most non-compete cases do, would be suitable for that court, we can request that it be moved there. But outside of that, or in other counties around the state of Florida, it's much more random in the sense that we don't have control over which jurist we're going to get. And so we don't know until the case is assigned, you know, whether it's somebody we've been in front of that we know is favorable to non-competes or not.
Right.
So what about employees that work in other countries? I think we have multiple issues there in terms of what does the language of the contract say? Would Florida law or really any US law be, you know, would it apply to an employee who worked and lived in a different jurisdiction completely? And so, I don't think we're going to be able to give a clear-cut answer there. Right. Like everything else, you know, it depends. But it does involve both contractual issues, jurisdictional issues, and international law issues in terms of the enforcement of contracts across country lines.
Yeah, I don't know without more that we would be able to even venture a guess as to what might happen, but it is just another layer of difficulty that we'll have to analyze and react to.
Well, I think one thing that's nice that people may not know is that we're part of an affiliated network of firms around the world. So our Meritos network, if you've worked with our Meritos firms in the US, we also have Meritos firms globally in almost every country where you're probably working. And if they're not in a particular country internationally, usually someone in the neighboring country is also a subject matter expert in the laws of that neighboring country, and they can get us the answer. So I've certainly used our Meritos affiliates overseas to answer some of the questions about the enforceability of contracts and what provisions would need to be included, because there are so many nuanced issues that I think go beyond the scope of what we typically consider when we're just looking at a state-to-state enforceability issues.
Right. Thank you.
Right.
What do you all tell clients when the question comes up about selective enforcement? Is it a problem or a challenge if a company has not enforced its restrictive covenant agreement, the same document, same language against employee or ex-employee A, and now they want to go after ex-employee B? And ex-employee B is going to say, wait a minute, it's not, it must not be necessary to protect the legitimate business interest of the company because they did not seek to enforce it against this other person, ex-employee A. So now they can't come after me. What are some of the issues to consider there?
Yeah, I think that it is a predictable defense that someone will raise to the enforcement of a non-compete. I think it is a issue that will be litigated, but frankly, I think it is a non-persuasive defense. I think that, if I am enforcing the agreement, I would hope it would make my job easier if the client always enforced their non-compete. It would make my job easier. I wouldn't have to address that defense. But I think the reality is clients selectively enforce their non-competes. Some employees are more problematic when they leave than other employees. And I don't think it matters as a legal event. I think it adds to the time and cost of the defense. But I think ultimately that argument is not a persuasive defense.
I agree more from a legal perspective, but I think as a practical matter, some judges are persuaded by the fact that, the company has permitted 5 similarly leveled, similarly situated employees to leave the company in the past 5 years, and they've never enforced their non-competes, and they all immediately started competing. And then employee number 6, who's also a mid-level manager, goes and starts competing, and suddenly we want to enforce against that employee. I agree as a legal matter, each contract should stand on its own, and the company can decide to selectively enforce. But I think it's better to either, always enforce, as you said, or to not have all employees on a non-compete, but use the non-compete selectively with certain categories of employees that you actually need to restrict competition from, and there's other categories of employees that you probably don't need to. And maybe all you need for them is a confidentiality agreement, or maybe a non-solicitation paired with a confidentiality agreement. If you have trade secret issues, we can address those as well. But having different agreements for different levels of employees, I think, helps you when you go to enforce as well.
Oh, I absolutely agree with that.
One size fits all.
Right. And I think that it actually hurts an employer if they try to have every employee sign a non-compete, because it takes, it's like if everybody, gets excellent on their performance review, then really they're just average, right? Because that's the grade. But I think that if you're serious about your non-competes and you identify who should be burdened by one, and then you enforce it against that selective group, you're much better off.
Right, and I always think it gives the employer seeking to enforce, if that defense is raised, then the employer can say, you're special, you are particularly valuable to the employer, to us, and it escalates the matter a bit. But we also see times where there are emotions involved with someone who has left the company, and the emotion is what is dictating the company's litigation strategy and potentially settlement strategy rather than actual harm to the company. So all of these things factor in, and like every other litigation matter in our courts, you're never going to get to a trial before mediation. So while there may be a preliminary injunction hearing prior to a mediation, there won't be a trial and ultimately a final injunction.
Right.
Not depending on the outcome until the parties have a chance to mediate and try to resolve things between them. Right. We're getting near the end, but we're not quite there yet. I wanted to discuss a little bit about some of the day-to-day questions that come up with the non-solicitation provision, and how does social media factor in? Like, what can former employees do and not do when they have a non-solicitation provision in their agreements, either as to customers or to employees of company A? Thoughts?
Well,
yeah, I'm going to follow Melody on this.
Yeah, so I think when it comes to social media is a minefield for litigation, and I think there's a common misconception by employees and really all employees, right, that what you put on your private social media is yours, and it's you can say whatever you want, whenever you want. And actually, social media creates a lasting written piece of evidence that can be introduced in court, just like a contract. And we have certainly used printouts from social media in trials, in evidentiary hearings for temporary injunctions to prove that an employee is soliciting either employees or customers or clients of the business. So just because it happens on social media and just because your page is private doesn't mean that it's not a violation. So I think it's important that you do monitor those pages to the extent you think there's a problem, because it's ripe ground, it's fertile ground for people to reach out. And obviously not all of those communications are things you can see, right? If I private message you and I offer you a job, you may not know about that. But if I post something or direct message somebody in a way that you can see it, post on their wall or something, for example, then you will know. And I do think there's a line, right? I mean, you can have a press release that says you're going to a new company, and that's not solicitation, but then you can also go too far. So social media is a place where people often let their guard down. Social media is a place where litigators like me love it, because we can usually always find some evidence on social media. People are just not as careful, I would say, as they are in email correspondence, where they're often more reserved in the way, or less overt, I would say, than things that they'll post. Comments to other people's pages can be solicitation. Really, it can run the full gamut. So there's certainly an area to watch, certainly an area to monitor and stay apprised of, and definitely evidence time to enforce in a court.
Right. And while you're 100% right that it is permanent, I am getting to the point where I tell clients or encourage clients, if they see it, print it, because it is transitory, at least for their access. And it is difficult, timely, and expensive to try and subpoena records from social media. So if you see it and if you're curious about it, print it and keep it and capture it.
Yeah, no, that's good advice. You can do a third-party subpoena, but as Maury said, it can be time-consuming, and you can end up having to litigate over that side issue, which you probably don't want to spend a lot of money on. So if you just print it in the first instance, and you have it, and you can introduce it as a record, during whatever proceeding you're having.
Right.
Thank you. I think we've responded to the questions in the Q&A. So if you have any final questions, those of you attending, please submit them into the Q&A. We have a couple of more minutes.
Right.
I had a related social media thought, but it has blown out, so I'll remember in a moment. Oh no, it's billboards. Are billboards considered to be a general advertisement? What if the billboard is within the restricted territory versus outside the restricted territory? What have you seen in terms of the development of the law on billboards? Oops.
I think it's hard to draw generalizations. I think that it is dependent on what the billboard actually provides and who paid for the billboard and who took it out and what it says. If the billboard says, XYZ welcomes somebody, we're going to fight for a long time about whether or not that's a solicitation. And I think that an ad, whether it's a billboard or in a newspaper or in any other form that's generic and taken out by the employer too, in my language, is probably okay. It depends if it goes further.
Yeah, I agree, Maury. I think generally the case law is, as long as it's general and just announces that you're now with XYZ company, the court's not going to find that that's solicitation. There's got to be more than that. Certainly, it could, if it says something bad about employer one, right, that could be defamatory potentially. I mean, there could be other causes of action. But in terms of enforcement of a non-solicitation provision, if it's a general announcement or general press release, I don't think you're going to be successful in enforcing that. It would have to be something more. Certainly, if it's targeted direct mail to your clients, of course you can enforce it. There are lines there, but I don't think a billboard on the side of I-4 is gonna do it in most cases.
All right, well, we're getting close to the top of the hour. Any final thoughts for our attendees today on the changing landscape of non-competes?
My closing thought would be to reread the ones you have and make sure that they are drafted to comply with the statute. I think the statute will probably get addressed in not next year, the year after. A lot will depend on what Biden does with the executive order that he signed and where that will go. But I think in general, it could be a very different landscape in a few years. And we just need to be vigilant about where it moves or how it moves.
Rachel, I did see that we got one final question related to whether a non-compete or non-solicitation can apply to an employee even if they give 2 weeks notice to the company. Yes, regardless of the amount of time that an employee gives prior to leaving, if you have a non-compete with them or a non-compete and a non-solicitation agreement, that would be enforceable and would, commence pursuant to your terms, but likely once they're no longer employed with you. So if that's 2 weeks or 2 months, frankly, it doesn't matter. It would still be enforceable. And I think
yes, I agree, but there is guidance that I think, those of you who have worked with us when we draft agreements, we typically put language into an agreement that says it will survive the termination of employment, because there is case law out there that is an escape clause or escape valve for employees. People have successfully made the argument that when the employment ends, so does the non-comp agreement. And so that is why, for those of you who are scratching your head, why we suggest that you put that language in the agreement.
And we also frequently put in tolling so that if the employee immediately starts breaching, you do get the full benefit of the 2 years or whatever your bargain for agreement was once the employee comes into compliance. And, that's the reason for that language. But I think from an employer perspective, as a closing thought, I would say remain hopeful. I think these employment agreements are still going to be a valid and very real part of your strategy moving forward. I do think the landscape is changing. I think the Biden administration is going to tighten, at least for certain categories of employees or certain sectors and industries like the construction and retail industries, some of the enforceability. But I do believe that Florida courts will continue to enforce non-compete agreements. It just may look a little different than it does today, but we'll continue to monitor all of those aspects.
Right. Well, thank you, Melody. Thank you, Maury. And thank you, everyone, for joining us today. We hope that you learned something, that have some takeaways from our webinar, and we will be sharing information soon about the next employment webinar offered by Lowndes. So thank you and have a great day.